Hello everyone, this is the video of Legal Studies, Class 12, Unit 2nd, namely the topics of law, and the last topic of this unit is administrative law that we have been discussing from last a few videos. In this video, I will be discussing something miscellaneous subtopics of administrative law that explained in your NCERT book. Okay. So, starting with the delegated legislation. As already we have discussed the delegated legislation while discussing the types of administrative actions. Okay, remember the administrative legislative action? So, that is the same thing. Nevertheless, we will revise the thing. So, what it is being said here? So first, if you remember that what is meaning of delegated legislation, first understand that the parliament is there. Its duty to make the law, to legislate the law. And we see that every act or law that is made by or legislated by only and only parliament. In case of the subject that belongs to union list. But in case of the subject that belongs to state list, then a state assembly or a state legislature has the power to make the law on that subject. However, apart from that, there are a number of works, number of things, provisions that are also required to be legislated, made, but it is not feasible in simple language for the parliament or a state legislature respectively to legislate everything. So what it does, it delegates those assignment to respective department. Okay, so that is known as administrative bodies. By the time we have discussed that, so you now understand. So these administrative agencies, bodies, whatever you call it, they have been given the certain powers to make certain rules, regulation. Okay, so that is known as delegated legislation. Okay, now I believe you very well understood the meaning of delegated legislation. So what it is saying here, just we will go through the words. To put it simply, when legislation proceeds from an authority other than the supreme authority. Supreme authority means what? That is parliament. So it is this supreme authority talking about the parliament. And what it is saying that other than that. Okay, other than the supreme authority. It means other than the parliament or a state legislature respectively, and is dependent for its continued existence as well as the validity on the supreme authority. It is called delegated legislation or subordinate legislation. But I will go back again here. Dependent for its continued existence as well as the validity on the supreme authority. So what does it mean that? So whatever the delegated power given to the respective administrative body, if it makes something like that, those provisions are ultimately dependent on the supreme authority. Means it has the duty, supreme authority has the duty or power to regulate that, to review that rules or regulations or provisions made by the subordinate authority. That's why it is known as also subordinate legislation, because it is made by subordinate authority, not the ultimate or supreme authority. Right? Okay, I believe now you understood this sentence. So let's move on. It is a natural companion of intensive form of governance, meaning that when a governance setup is so spread out that it is not possible for the top legislative authority to directly reach out to the grassroots or its own strength, it can be legitimately expected that rulemaking would vest in the appropriate or corresponding administrative authority. So it is the same thing that we have discussed already in the introduction part, that when something that is not feasible for the supreme authority and everything is not feasible for the supreme authority, so what it does, it simply transfers or delegates those powers to the subordinate authority. In our case, it is known as administrative authorities. Okay, so that is the same thing. Now, move on the next sentence. This also opens the avenues of a specialization of law where regulation can be more aptly framed for the specific need of different regions in a diverse land like India. So this is something like that, talking about the various aspects and something that a specialized body can do, as saying opens the avenues of specialization of law. Okay, so if same body making everything, then it is difficult. But if some bodies who are specialized in a specific work and all, if they are doing that work, it is of course something like much appreciable than if someone else who is not of that field making the same thing. So it is talking about the such kind of aspect. And one more point that I would like to discuss here, as it is said here, aptly framed for the specific need of different regions in a diverse land like India. Means India, you know that it is a very big country and very diversified in terms of geography, in terms of environment, climate and everything. So depending upon the region, what its requirement is, if the plan and policy is made accordingly, that is wonderful. And we know that a single plan cannot work in every kind of environment. So if one person is supposed to be making the policies of such type for entire country, then that is also not good. So it is another benefit of delegating the legislative power. Okay. Moreover, crisis emergency legislation is also possible in such a situation. Sometimes it is parliament maybe not in session or something like that, some urgent kind of legislation required. So such kind of bodies can make the laws. Okay, so that is in crisis or emergency situation. So moving on, however, it must be remembered that no delegation must be unfettered, as no democratic society can ever afford accountable authority to govern against a popular will of the people. What does it mean? Let's check out again. However, it must be remembered that no delegation must be unfettered, as no democratic society can ever afford an accountable authority to govern against the popular will of the people. So what does it mean that? Just focus on this part. No delegation must be unfettered. Means any power that is given to the respective authority must not be unfettered. Unfettered means something that is uncontrollable, something that there is no control over that. So, and that is not feasible in democratic society. So it must be controlled or something like that, that can be reviewed, that can be corrected, that can be, if it is not reasonable, that can be removed. Okay, so everything is possible. So it is not something like that in such a democratic setup. Any delegated legislation is uncontrolled or arbitrary, not at all. So everything, whatever the legislation done by these authorities, that is the matter of review. Okay, it's not that is ultimate. No, that need to be reviewed, and if it is unreasonable, unconstitutional, then it must be dropped. Okay, so hence delegation of law making power to the administrative authorities, as has been shown in welfare state is often controlled. See? So I believe now it is very simple for you to appreciate the sentence. Now, see next sentence. In view of a written constitution, such delegation cannot be unlimited and must always conform. It's not conform, it's conform to the basic features of the constitution as well as the ambit which is given for the delegation of the corresponding legislation. So conform means in uniformity, means following the constitutional provisions. It's not something like out of way. Cannot be unlimited. It is limited. And always conform to the basic features of the constitution. So whatever the guidelines of the constitution, it must follow, right? Okay. So now, moreover, essential legislative functions cannot be delegated. Okay, so this is another kind of thing. Some kind of the work of such type that cannot be delegated. That has to be done by the supreme authority itself. While appreciating the doctrine of delegation of powers, care must be taken in not reading too much into it. So it's simple. Now you can appreciate the whole concept of delegated legislation. So in gist, we can say that everything is not possible for the supreme authority. So supreme authority delegates some of the legislative powers to the subordinates or administrative bodies. Okay, and they make the rules, regulations, provisions. The second aspect is that such power of these administrative bodies are not unfettered, means something like not which cannot be controlled. It is very much under the premises of, under the purview of the supreme authority. If sometime it is wrong, then it must be corrected. Okay, and lastly, it must follow the guidelines of the constitution. Okay, so this is the concept of delegated legislation. Okay, the next topic that we have, that is administrative law in ascertaining the policy of any given legislation. What does it mean? That this topic simply discusses about the certain rules and regulation that confirm or provide the provision of delegated power or legislation. Means if supreme authority giving certain rights or powers to legislate certain rules, provisions to its subordinate, then there are certain rules and regulation that defines such activities. So that can be given the reference while delegating such power, right? As here saying that, you can see that moreover, the head notes and section names of statutes can also be used, and if need be, external sources of interpretation like parliamentary debate can also be used for ascertaining the purpose of law. Okay, so this is the basically talking about the rules and regulation, where it is mentioned that the subordinate or administrative bodies will be given such power. Okay, that is supreme authority not doing it suo motu. Keep in mind, it is doing within the given framework, within the given provision, and that need to be quoted whenever someone asks something like that. Someone raised the question, then that need to be quoted, because under this law it is being done. Okay, so now the next topic we have, that is mechanisms of control against illegitimate administrative process. It is interesting that it is saying something like that: if these administrative bodies or subordinate bodies doing something that is not within the framework, that is not within the given guidelines, then how to control that? first understand the topic. Okay, so in that case, what to do? See how it started. It is saying that giving the reference of two countries of the world, in the United States of America, the procedural control is effective within the prescribed guidelines. Okay. Secondly, in the United Kingdom, parliamentary control is extremely strong and effective given that theirs is an unwritten constitution with supremacy of parliament. So here in the United States of America, there is procedural control. Okay, and in the United Kingdom, Parliament has the supreme power. But in India, what is the condition? It is neither the procedural control, that is President's control, it means, nor the Parliament, which has an absolute power. So in India, what is that? Neither President nor Parliament has the absolute power. So in case of India, neither President, that is executive, nor Parliament, that is legislature, has the absolute power. Okay, hence Indians turn to the judiciary to frame the scope of administrative anomalies and privileges of the Parliament. So in such a case, what happens that judiciary comes into the picture, right? So judiciary's role starts from here, and so if there is any anomalies, any discrepancy or any confusion or anything of such type, then judiciary or Supreme Court comes into a picture and decides. In such cases, the court starts with a presumption of constitutionality. Okay, it will be clear once I read the next sentence. That is, if for a law, rule, regulation, two interpretations are possible, the court will follow the one which makes the law constitutional. See, everything is talking about the constitutionality. Okay, so whatever the things that fall under the constitutional framework, so that is within the provision, that is okay, reasonable, logical. But if something doesn't fall in that, then it is unconstitutional. And if it is unconstitutional, then there is no way that going to be implemented, enacted. Okay, so this is how the judiciary plays the role while deciding the things what is constitutional and what is not. So check out the further sentence. The court may also read down or read up the law in order to uphold the constitutionality. Okay, so it's a duty of the court how to prove it constitutional and how to prove it not constitutional. So it is the completely within the framework of judiciary. Hence, a balanced and holistic approach is adopted while assessing and adjudicating upon administrative matters, since the court has to always aim at delivering justice and at the same time ensure that it doesn't transcend its own domain and pose a part of the legislature. Well, see, as of now we have read that judiciary comes into a picture and decides the thing what is within the framework of the constitution and what is not. But here the last line that you need to focus on, that it doesn't transcend its own domain and pose a part of the legislature, means judiciary has also the limited power. Its power to decide the thing whether it is constitutional or not, but it has no power to legislate the things. Okay, because the power of legislation is only given to the legislature. So all the branches of the government has been given the separate power and no one supposed to be interfering with each other. that we have already discussed while discussing the principles of administrative law, and then under that we have discussed the separation of powers. Okay, so there we have discussed how to check and balance the things, right, within the given framework. Okay, so I believe now you can very well correlate one with other. Now the next topic that we have, that is grounds of challenge of rules and regulations. So what does it mean? That if some of the actions of administrative bodies that is not reasonable, not fair, not constitutional, so how you can, or on what ground you can challenge that rules or regulations? Okay, so see what it's saying here. Rules and regulations framed by administrative authorities can always be challenged. See, remember the word unfettered. So it is not unfettered. If it would be, then there is no way to challenge that. If it is within the control, and always question can be raised. This is why it can be challenged, right? On the grounds of uncertainty and vagueness. So here two grounds are mentioned. Uncertainty. So if any plan or policy that is uncertain or it is vague, means not clear, then it can be challenged, right? Next sentence saying arbitrariness is in the presence of non-causality between the rule and the object sought to be achieved by the said rule. So we have also discussed this part, arbitrariness. That shouldn't be there. Okay, so the next sentence will clear this further. It is also clear that when there is a patent denial of equality, arbitrariness will be enforced. But it is saying that if something that denying the equality, then arbitrariness will be enforced. Then some action must be taken in order to ensure the equality. Furthermore, reasons form an essential aspect of administrative action, as dearth of reasons reflects the non-application of mind. The value of reasonableness in administrative law has increased manifold times, especially in the post-Renaissance period. To decipher the reasonableness, one needs to pay attention to the prevalent customs, traditions, and practices while acting under ambit of administrative law. Okay, it is saying that as society, the culture of the society, not always same, rather keeps on changing. Okay, so what is reasonable and what is not? Whatever the policies made by administrative bodies, those are applicable to the society for whom it is made. That depends upon the time. Okay, so if today something is reasonable, that may be not reasonable after a few years. Okay, so that's depend upon time. So accordingly it need to be changed and all. Okay, now the next topic that we have, that is control over administrative discretion and rule making. What does it mean? Means the term that is something like misunderstood at this point in time, that is of course discretion. Okay, discretion here in this context, the meaning of discretion is something that exclusive, something that a person who is in power at that point in time, he has been given certain power to choose what is correct for that point in time, for a group of people. What does it mean? That let's understand with an example. See, there are more or less everything is already predetermined, such kind of policies and all that, everything is predetermined almost. But But in certain case, the thing that is already predetermined, if that is not applicable in particular circumstance or in particular that group, so in that case, that administrative authority has the power to choose or to make or to decide what is applicable, reasonable action for that particular situation, for that particular circumstance, for that particular group. So it can decide accordingly. It is not always that need to follow the rule book. Sometimes it can use discretionary power. You can say like that. Okay? So now you understood control over administrative discretion and rule making. So such power of course is given, but it is also not unfettered. Keep in mind. Those officers have this power, but it is of course under the purview of the authority, and that can be reviewed, that can be taken back if it is unreasonable. Okay, so that is discretion. Now see what it is saying. Under the Constitution of India, the general parliamentary control in the form of debates, notices, adjournments, etc. operate as a potent weapon. So see, if some laws, some policies are being introduced or some bill introduced in the parliament, what happens? The parliamentary debate, notices, adjournments. So there are so many functionalities of the parliament in order to pass a bill. It's not like that it can be, okay, someone introduced and it is passed. So these are the tools, techniques, modus operandi to pass a bill, right? So that is regarding the rule making. Okay, now special controls such as the lay-in provisions and consideration for special committees are also of prime significance. You know that there are different parliamentary committees that is time to time formed, and there are some parliamentary committees that is permanent in nature. So those things keep the things in balance. Okay, so no one's supposed to be just coming arbitrary and making the things as he wishes, right? So lay-in provisions refers to delegated administrative rules that are laid on the table of the House and only on the approval of the Parliament or the respective legislature will those rules said to have the power of law. Okay, so if something is passed by Parliament finally, so that is the rules to have the power of law. Okay. Further, lay-in turn can be of two kinds, recommendatory or mandatory. While in the former, affirmative parliamentary approval may not be required. Recommendatory, for this, affirmative parliamentary approval may not be required. But in the latter, that is for mandatory, such approval is non-negotiable and vital. Right? Delegated legislation is always subject to judicial review on the standards of the Constitution, the Parent Act and others. Okay, so this is again the repetition of the information that we have already discussed above, that how these are the things being controlled, right? So if something is delegated, it doesn't mean that is ultimate, unfettered, right? Okay. So now the next topic that we have, remedies under administrative law. So remedies, in the sense, if something wrong happen, then who will be responsible? If because of some of the administrative body's action, an individual or group of people suffered something, then who will be responsible and what is the remedy for that? So this solution is again given by the administrative law. The government machinery has the statutory immunities. What does it mean that the government machinery has the statutory immunities, but if it found guilty, then it cannot use this statutory immunities. Okay, in that case, these immunities will be silent. I say against any wrongs on the people, right? You can see here. Administrative law provides various remedies which a citizen can seek against a wrongful administrative commission or omission. So both the actions. If administrative action that did something wrong that causes harm to people, okay, or if an administrative body responsible to do something but didn't do, in that case, if people suffered, so that is omission, because it had the duty to do that but it didn't. So in both the cases, commission means did something that caused harm to people, and omission means didn't do something that it obliged to do. So in both the cases, the common is injury, harm of the people, then the respective authority will be responsible for that. Okay, so there are different kinds of remedies available against wrongful actions. Different statutes provide for guidelines and benchmarks which are to be adhered to by the administration. Okay, so there are certain written guidelines that need to be followed. For example, the Indian Evidence Act deals in detail with when and how can public officers be compelled to disclose information. So you can see that right to information, that is another remedy. Okay, so you have the right to information. Apart from constitutional and statutory remedies, control over the administration can also be exercised by non-constitutional and non-statutory means, wherein the media and the social media assume an important role. So here we have also this aspect covered, that is social media and all, some of the action that doesn't fall within the constitutional framework but it is not reasonable. So in that case, media or people through social media can raise the question and seek the natural justice. Okay, so this is all regarding the miscellaneous concept of the administrative law. In next video, I will discuss a comparative analysis, that is Detroit system, in detail. It is a comprehensive topic, so we will discuss in detail in a single video, right? So this is all for this video. However, if you want to have just fast recap, then you can see that what are the terms that we have discussed in this video. Okay, starting with the delegated legislation, the hot spot of administrative law studies. And next we have discussed administrative law in ascertaining the policy of any given legislation. Next we have discussed mechanism of control against illegitimate administrative processes. And next one, grounds of challenge of rules and regulations. Next one, control over administrative discretion and rule making. Next one, remedies under administrative law. So this is all for this video. See you in the next video.